Evening. The May 22nd, 2025 Arlington County Board of Zoning Appeals hearing is now in session. Good evening and welcome. I'm Richard Kaplan, Chair of the Board of Zoning Appeals. Boy, this is a little disconcerting.
Yeah,
It's not mine. It's the one in the room.
oh.
With us remotely. To avoid disruptions, we ask that you please place your mobile devices in silent mode. Before we begin tonight's hearing, I will discuss this board's power and the procedures for tonight's hearing. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the again. Someone muted me. First, the BZA can approve use permits that allow modifications of placement requirements.
Blake, we can't hear at home.
Yeah. Let's try that one more time.
In order to approve a use permit, the Arlington zoning ordinance requires this board find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood. Can I be heard now?
Yes, you can. Thank you.
Awesome. Will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. In making these findings, the BZA shall consider whether the modification will promote compatibility of the development with the surrounding neighborhood because of the structure's overall size, footprint, placement are similar to those of the structures on the property surrounding that lot in question, and whether the modification will help preserve natural landform, historical features, and or significant trees or foliage. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary and in the public interest, including but not limited to the duration of the use permit. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the strict application of the ordinance would unreasonably restrict the utilization of the property, and the need for a variance would not be shared generally by other properties, and such variance is not contrary to the purposes of the ordinance, or that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting of the variance would alleviate a hardship due to the physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested on behalf of a person with a disability. In all variance cases, the property for which a variance is being granted was acquired in good faith and any hardship was not created by the applicant. That the variance granted will not be a substantial detriment to adjacent properties and nearby properties in the proximity of the geographic area, that the condition of or situation of the property concerned is not so general or reoccurring in nature as to make reasonably practical the adoption of an amendment to the ordinance, that granting of the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. Third, the BZA shall hear and decide appeals of the zoning administrator or from any order, requirement, decision, or determination made by any other administrative officer in the administration or enforcement of Title 15.2, Article 7 of the Code of Virginia. In exercising its powers, the board may reverse or affirm wholly or in part or may modify an order, requirement, decision, or determination appealed. The determination of the administrative officer, zoning administrator, shall be presumed correct by the BZA. The appellant has the burden of proof to rebut the presumption of correctness by a preponderance of the evidence. The board shall consider any applicable ordinance, laws, and regulations in making its decision and must base our judgments on whether the administrative officer was correct. The concurring vote of a majority of the membership of the board shall be necessary to reverse any order or determination. Now on to tonight's hybrid hearing. For those who are participating in the room, somewhere you will find a QR code linking to the application package, including the staff report for each case before us this evening. They are also available on the website. For those participating virtually, a copy of the application can be found on the Arlington County BZA website. There is a link in the chat for the application packages. I recommend that if you have not yet seen the report for your case, that you review that case before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and cameras off until called upon. Turn off the sound and any other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned public testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask questions of staff that they may have. Applicants or their representatives will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the items will be called. Speakers must fill out a speaker slip, which is online or available on a table in this room. I think. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit any cross-examination or direct questioning by others. For tonight's hearing, this board has deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, and 3 minutes for representatives of organizations, and 2 minutes for individuals as sufficient. After the board has gathered all the information we need and have discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Please be respectful of the time allotted. This is a public forum, and tonight's hearing will be recorded and posted to the county's website. All information with tonight's hearing, whether spoken or written, is subject to the Freedom of Information Act requirements. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Before we call the first case, we have a couple of administrative matters to attend to. Do I have any board members who are attending virtually tonight?
Hi, Mr. Chairman. I'm here. This is Alex Kumana.
Thank you, sir. I did not see your name down there, so I wasn't sure if you were here. So tonight I have a request from BZA member Mr. Kumana to participate virtually. Virginia law requires that an in-person quorum be present, and as such, I will note that we have an in-person quorum for the record, being that we have 3 members up here. Mr. Kumana, can you please certify that you can hear me?
Yes.
Thank you, and I will certify for those of us in the room that we can hear you. Second, I would like to welcome back Mr. Bowen and seek unanimous consent from my colleagues to appoint or reappoint Mr. Bowen as BZA secretary. Hearing no objection, welcome back.
Thank you.
I would also like to thank Ms. Ryan for filling in Mr. Bowen's absence. Next, we have an appeals to get scheduled. I have been informed by staff that appeal ZAPP 25-007 is deemed complete. Fees have been paid, and as such, I would like to again seek unanimous consent from my colleagues to schedule this for our hearing date on July 16th of this year. Any objections? And that appeal is scheduled. Lastly, I would like to seek unanimous consent from my colleagues to reorder tonight's agenda for appeal item number 3-V12042-25-APP-1 to be the last item on our agenda. It's our custom that we hear appeals at the end of use permits and variances. Any objection? Excellent. Do my colleagues have any other business to address tonight? Mr. Bowen, can you please call the first two cases together?
Yes, Mr. Kaplan, I just want to ask, can our virtual attendees hear me as I'm speaking?
Yes.
Yes.
Great, thank you.
Yes.
The first two cases on the agenda are case number V-12036-24-APP-1. This is an appeal by Shannon Peak on behalf of Alex Wilson of the Community Planning, Housing and Development CPHD Director's Letters declaring EHO permits ZEHO 23-00067 and ZEHO 023-00022 void on properties located in the R5 zoning district on the premises known as 1225 North Quincy Street, RPC number 15-083-017, Boston, Virginia Square, and in the R6 zoning district on the premises known as 5041 to 5043 25th Street South, RPC number 28-026-018 within the Claremont Civic Association.
Thank you, Mr. Bowen.
I'm sorry, one more case. The second case is case number V-12041-25-APP-1. This is an appeal by Shannon Peak on behalf of Alex Wilson of the Community Planning, Housing and Development CPHD Director's Letter declaring EHO permits ZEHO 23-00067 and ZEHO 23-00022 void on properties located in the R5 zoning district on the premises known as 1225 North Quincy Street, RPC number 15-083-017, Boston, Virginia Square, and in the R6 zoning district on the premises known as 5041-5043 25th Street South, RPC number 28-026-018 in the Claremont Civic Association. In both of these appeals that I just read, staff recommends that the board defer the subject appeal request made at the appellant's request to the October 15th, 2025 BZA hearing. Please note that we do have a supplemental material for this case, and that was in an email with 3 attachments that came from the applicant.
Thank you, Mr. Bowen. Is the applicant or their representative with us?
Yes, this is Zach Chapman on behalf of Alex Wilson, standing in for Shannon Peak.
Thank you. So can you confirm your desire for a deferral to October 15th?
Yes,
And I assume that staff is in agreement with that deferral?
Yes.
Is there anyone here who has come to speak on the first two items, for or against? Would any of my colleagues like to make a motion? Or have any comments? Happy to try to.
Yeah, and Mr. Chair, we heard from some of the virtual attendees that the mic is working much better than the Teams mic, so we might have to pass those back and forth. I think so. There's 2 case numbers.
We okay? Super. Separate interest, okay. I move that the Board of Zoning Appeals defer the B-12036-24-8-1 and B-11041-25 AP-1 to the October 2025 BZA hearing. Second.
A motion made by Ms. Malice and seconded by Ms. Freshman for a deferral on these 2 cases to the October 15th hearing. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for deferral passes 4-0. Mr. Bowen, can you please call the 4th item on the agenda?
Mr. Kaplan, I believe that Ms. Malice made a motion just for the single appeal, calling the single appeals case number. So we may need to make a separate motion. And I don't believe I heard, at least, and we can confirm with any colleagues that might have heard differently, but I don't believe I heard a motion specifically mentioning case number V-12041-25-APP-1.
-8 on for this matter to the October 2025 APA hearing. Second.
A motion made by Ms. Freshman and seconded by Ms. Malice and seconded by Ms. Freshman for a deferral to the October 15th hearing. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 4-0. Mr. Bowen, can you please call the fourth item?
Absolutely. The fourth item on our agenda this evening is case number V-12043-25-UP-1. This is a use permit request by John Linham Jr. on behalf of Carlton and Amy Lorenz. The owners permit a street setback of 21.2 feet to the building wall, 19.8 feet to the building eave instead of 25 feet to the building wall, 21 feet to the building eave as required, and to permit a street setback of 15.2 feet to the porch, 14.9 feet to the porch eave instead of 21 feet to the porch, 19.5 feet to the porch eave as required, all from the North Vermont Street right-of-way, regarding a two-story addition and new porch over an existing non-conforming garage, a new patio, a new grill, and a spiral staircase to an existing one-family detached dwelling on a corner lot in the R10 zoning district on the premises known as 4437 33rd Road North within the Groff Branch Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And we do not have any speakers who have signed up to speak on this case in advance, and we do not have any supplemental materials for this case either.
Thank you, Mr. Bowen. My colleagues have questions for Beth.
Just a quick question, just to clarify. Staff report mentions that the porch is being built over an existing non-conforming garage. Is it non-conforming in location only?
I will defer to Mr. Goldberg, who wrote this. I believe that, yes, the street setbacks from North Vermont Street are non-conforming. To our knowledge, like things like coverage and height, which could cause nonconformities, are not an issue.
I
Mr.
can
Goldberg, or
help
Ms.
right
Ryan,
out.
thank you.
Sure. So on the existing plat that I have on the screen, the existing garage is 15.2 feet to the building wall instead of the 25 feet it should be from North Vermont Street. Right here, 15.2.
Thank you, Ms. Malice. Anything further from my colleagues? Is the applicant with us?
Yes, I'm Carlton Lorenz.
Would you like to speak to your application?
Only to say thank you to the staff for recommendation, and I'm happy to answer any additional questions if there are any.
Thank you. Do my colleagues have questions for the applicant?
Yeah, I'm just curious about your neighbor feedback. Typically, we like to see feedback and outreach to all the neighbors on all sides. And I only had 4 of your neighbors and 3, including the one immediately north of you, that we don't have any feedback on. So could you discuss your outreach, please?
Sure, yeah. I believe we have feedback from the neighbors on the immediately to our right in this view and behind us, as well as across the street, across Vermont, and also across 33rd Road. We sent emails to all of the neighbors that were directly adjacent to us, as well as further up the street. So anyone who can kind of see the house from their house, and then followed up by text and phone call. We got emails as well as a couple of written responses all positive and supportive.
Ms. Malice.
You have a neighbor, George Johnston.
I do. Yep.
Do you know his address?
If you give me 1 second, I could look it up. I don't know off the top of my head. Just one second.
I just wondered if, because I think that Miss Freshman was mentioning that your neighbor, one of your neighbors immediately adjoining, we didn't have the feedback on, and just wondered if that was George Johnson.
No, George is a couple of doors down.
Okay,
He's 3415, Vermont.
so 3401.
Yeah, the
you had
price.
Did you have feedback from them?
We got an email, a supportive email from them. I can go and check my folder. I believe they submitted something in writing, but we definitely got an email from them that indicated that they were supportive. It didn't have like a, it wasn't a full write-up.
It might not have gotten into the packet.
Okay, yeah, I can. If it's helpful, I'm certainly happy to find that and forward it. But we've talked to them multiple times.
Okay.
Our neighbors at 3328, 3401, 4406, and 4431 have all expressed their support and enthusiasm.
Yeah, that was the key one that was missing.
Okay.
Anything further from my colleagues? Discussion or motion? The motion slide.
Oh, Mr. Johnson, are you looking for it, or can we just proceed? I guess we're going to just proceed with their motion.
And Ms. Ryan, if you're able to advance the PowerPoint presentation, if there is a motion slide, that would be much appreciated.
Thank you, Ms. Malice.
Second.
A motion made for approval as advertised by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 4-0. Good luck with your project.
Thank you.
Yeah, and thank you, Ms. Freshman. Can you please send that form, the feedback form from the rear neighbor to staff so that they can include that in their records?
I will. Yes. Thank you.
Thank you. Mr. Bowen, can you call the next case?
Yes, Mr. Kaplan. The next case on the agenda is case number V-12044-25-UP-1. This is a use permit request by Ryan Linderman and Amy Weber. The owner is to permit a street setback of 6.2 feet to the building wall, 4.8 feet to the building eave, instead of 25 feet to the building wall, 21 feet to the building eave as required from the North Fillmore Street right-of-way, to permit a left side setback of 8.1 feet to the building wall and porch instead of 10 feet to the building wall and porch as required, and to permit a total aggregate side yard width of 14.3 feet instead of 18 feet as required, regarding a new 2.5-story addition, a rear porch, a front porch, replacing an existing non-conforming foundation walls on an existing one-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 2814 3rd Street North within the Lion Park Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. We have not received any supplemental, or excuse me, we have not received any speaker slips for this case, but we have received a supplemental material, which is a letter of support from Matt and Amanda Hawkins, the neighbors to the west.
Thank you, Mr. Bowen. Do my colleagues have questions for staff? Ms. Malice.
Just a clarification, I think it's pretty obvious that Fillmore has has a stub that's Fillmore as well as the main Fillmore. That the stub is called Fillmore and the street parallel to that is called Fillmore.
Well, because it's two sides of the same street.
With the house in between.
No,
I'm sorry, was that a question or more of just a
That's
remark?
question.
Okay.
Because Fillmore runs in front of and behind some houses.
Correct. I will throw that to Mr. Goldberg for confirmation if he is able to speak from his position. But yes, I believe that is correct. Sorry. That is correct.
So that little stuff, that is Fillmore Street.
Yeah. I think that mic is not on.
And I'm sorry, we have to be able to hear everybody. And everything is there.
That is,
The little stuff.
yes, the little stuff is.
Thank you, Mr. Goldberg.
Sorry to just walk off.
Is the applicant with us?
Yes, this is Ryan Lindeman.
Would you like to speak to your application?
No, nothing to add. Just that we recently purchased the property and my wife and I are looking to redevelop it. We believe the requests are reasonable and it's in line with the compatibility of the neighborhood and precedent with the rest of the homes in the area.
I have a question on your neighbor 2810. Right next door, we don't have any information on, it would be the most impacted.
Yeah, so we received written support from 301 across the street, from 235 just across the pipe stem, and also 236 next to 2810. We didn't get a written response from 2810. However, I have spoken to him and I have exchanged several text messages with him. He's supportive.
Is it possible? Is it possible to provide that documentation?
Yes. How should I provide it?
Can you take a screen capture on your phone and send that into staff?
Absolutely. I can show you right now on camera if you want.
Sure.
All right, let me pull it up real quick. So the owner's name is Chris Carr. Wait for that to focus for a second, if it will. Oh,
You probably have your background blurred.
yeah,
So
let me
it's-
fix
it's
that real
background.
quick. And then maybe it'll focus on my screen. Just seeing if it's showing up. I don't know. It's not showing up super well.
You can just send that into staff.
Yeah. So that's Chris Carr.
Just to
He's
put it in the record.
exchange text. He's supportive. All the neighbors are very supportive. That house has been there for a long time.
Thank you. Any further questions or comments? Everyone? Good.
Oh,
On your screen.
I know.
I'll move that the Board of Zoning Appeals adopt the attached proposed resolution granting the use permit V-12044-25-UP-1, subject to the conditions listed. Is there a second?
Second.
A motion by the chair, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 4-0. Good luck with your addition. Mr. Bowen, can you call the next case, which I think is a variance?
That is correct, Mr. Kaplan. The next case on the agenda is case number V-12045-24-VA/3, a variance request by Joseph Sherdull on behalf of Carbright Enterprises LLC, the owner, to permit construction of a new one-family detached dwelling on a property with insufficient lot area and lot width requirements for the RA 1426 district, to permit a street setback of 9.9 feet to the building wall, 9.2 feet to the building eave instead of 25 feet, 21 feet to the building eave as required, to permit a street setback of 5.6 feet to the porch platform and porch eave instead of 21 feet, 19.5 feet to the porch eave as required, to permit a right side setback of 4.2 feet to the building wall, 3.2 feet to the building eave instead of 10 feet, 6 feet to the building eave as required, to permit a right side setback of 3.1 feet instead of 6 feet as required, to permit a right side setback of 4.7 feet instead of 8.5 feet as required, to permit a left side setback of 5.9 feet, 5.6 feet to the building eave instead of 10 feet, 6 feet to the building eave as required, to permit a left side setback of 3.6 feet and 2.3 feet to the stormwater planter and area way respectively instead of 6 feet as required, to permit a total aggregate side yard width of 10.1 feet instead of 18 feet as required, and to permit a height of 35.3 feet instead of 35 feet as required regarding a new one-family detached dwelling in the RA 1426 zoning district on the premises known as 5389 8th Road South within the Arlington Mill Civic Association. Staff recommends that the board adopt the attached proposed resolution denying the variance request. An alternative resolution has been provided should the BZA see fit to approve the variance request as advertised. Please note that we do have additional speakers who have signed up to speak on this item, and we do not have any supplemental materials at this time.
Thank you, Mr. Bowen. Do my colleagues have questions on this item? Ms. Alice?
So this is a variance request. And yet it also includes a lot of setbacks. Typically variances have one report and setbacks and have a separate report as a use permit. This is all together. I'm trying to understand why it is.
Yeah, absolutely. The BZA use permit process for setback modification is only allowed in certain zoning districts, the single family zoning districts. So when we have a single family house that's proposed in a multifamily district, such as the RA 1426, everything that has an exception comes in the form of a variance.
Could I ask, when was this sold and purchased, and what's the existing by right purpose of this non-conforming triangular plot amongst
I'm sorry,
apartment buildings?
Mr. Kamano, can Ms. Malice finish her question?
Oh, sorry, it's
I
hard
will-
to hear other than you.
Yeah.
I'm sorry.
No, it's okay. I will call on you shortly.
Okay, so I heard in the staff or read in the staff report that height is also over.
That is correct. There were some different heights mentioned in the architectural drawings attached to the staff report. We went with the 35.3 figure as that was the height that required the variance. So
So that's in here too. So those are the typical height and coverage, is that in here too?
they are not seeking a coverage variance.
Okay. So I think that answers my questions. It's all being done as a variance.
Mr. Kamano, you're up.
My apologies again to the vice chair. It's hard to hear and see from over here. Yeah, I just wanted to know when was this purchased and what's the by right use of this land? Like what? I guess I've just never seen this before. Like a small triangular little plot next to apartment buildings. If we don't know, that's okay.
Yeah, this report was a collaborative one between me and Mr. Rissy. So I did want to see if Mr. Rissy wanted to take a stab at that question. In terms of the lot buildability, its area is insufficient and width is insufficient to really accommodate any use in the RA 1426. So to be rendered buildable at all for any use, it would require a variance. So I think that answers part of your question, Mr. Kamana.
And Mr. Kamana, this is Stephen Rissy. The answer of the most recent sale was in December of 2017.
Thank you. Thank you both. Nothing further from me, Mr. Chair.
Thank you. Is the applicant with us?
Yes. Please correction. I sent it to you on Wednesday. And I had you have copies here. Okay. Do you have 6 copies? Which is so here are 6 copies of these are with average grade is 34.4, but the building height is 34.0. Okay, thank you. As well as updated plan. Okay, thank you very much. And lastly, we got 2 more signatures. Both of them are really present buildings across the street. One's at 5320 and one's at 5319. Okay, thank you very much. Good evening.
Good evening. Would you like to speak to your application?
Yes, I would.
And before you start, identify yourself.
Of course.
Yes.
My name is Steve Sherrill. I am agent for Carbide Enterprises. I'm also the son of Mr. Sherrill, the owner of Carbide Enterprises. Mr. Bowen is giving you right now a updated plat and plan set that reflects that we are not looking for a building height exception. There was a miscalculation on the plans. We have a plan and plat there reflecting the building height is 34.9. So we will not be seeking a variance.
Right. I think that being the case, we probably want to allow staff to do more analysis on this and update their report. I'm not, Ms. Mellis?
Well, we typically don't make changes to the plan, not until staff has reviewed it.
That may be the case. Yeah, there was 2 figures on the plan and one of them was incorrect. I'm not sure if you guys would prefer to proceed or if there was a pro, or if I may confer with my colleagues for just a brief moment. You guys are deciding whether you want
Yeah,
to.
typically we wouldn't make changes on the guys.
Okay.
Because then my next question to staff would, does this affect the recommendation? And they are likely to tell me that they need time to do that analysis. They're not prepared to make that decision. And then we haven't looked at it either. So
That's a fair point. Would you allow me 1 minute?
please, go ahead. Right, Mr. Bowen, I will assume if I were to ask you, does that change the county's recommendation? Your answer to me would be,
I think it's most appropriate for it to do a full analysis of the new plan set.
thank you. I guess I should not assume what staff's response would be. If
Small on.
And we already get this one's there, remember?
Mr. Bowen, if we were to come back for a deferral to our June meeting, would staff have enough time, or does it have to go further out?
I will ask for Mr. Rissi's input as well, since this was again a collaborative report. The height is changing by just a couple inches. So in my mind, that would probably be sufficient time for us to do that. Mr. Rissi, do you have a different impression? Yeah, if it is indeed only the height, I think we would need to take a look at the other factors to make sure nothing else has changed. But if it's just the height, one detail, I think the height analysis could be done within a month. We do have our June meeting is a little bit earlier than it usually is. It's earlier, so that does compress our timeline a little bit. So I think it's definitely an issue that I would want to get a second opinion on from Mr. Rissi as the co-author of the report.
Sir, you need to look at the whole deck, to see if everything else is the same as what was presented tonight. So it's not just a matter of one number. have to look at all, the whole package.
Mhm.
It's your recommendation for us to defer, then I would follow the recommendation of the board because I don't probably.
I mean, we're providing a recommendation. It's just, we can go forward on the plan before us, or if you want to make changes to the plan, then we can defer and then revisit after we have a complete package from staff. So we're not recommending, we're just telling you what the options are,
Understood.
right? So we can either go forward on the plans you've submitted tonight, or we could defer till, it sounds like June would be sufficient. Unless my colleague wanted to push it further out.
Yeah, we have not
on the
yet,
new plan.
we have not yet advertised the June agenda, but we're going to advertise it very soon.
Right.
So,
And so I leave that to staff, whether you feel that you're very soon is enough time to add another one.
yeah, and I don't know if Mr. Rissy, is available to comment. July is certainly safer, given that we are about to advertise the June agenda. Yeah, the hearing is the 11th, so we got to advertise it really 2 weeks before the 11th at the very least. So that would be in the next.
We're advertising, we're
yeah,
sending it
next
to the
Tomorrow.
newspaper tomorrow.
Well, I mean, that's really a staff decision. I'm
Yeah.
not sure that the board has a.
I think it's probably most appropriate for July in that
July.
case,
Yeah.
because that is a very short time frame. With the June hearing being like a week earlier, that does compress our time frame a little bit more.
Right, so your choice is essentially deferral till July or move forward with the current plans.
July 16th.
Thank you.
I appreciate your patience. Thank you very much. I'm at the position where if you feel that you would be willing to hear what I have to say and consider it, and you guys need to go back, and if you want to approve it on the condition that everything is reviewed afterwards, if that wouldn't work, then we'll go ahead and take that into account. If it's at all possible for June, it would be appreciated. If not, totally understand.
Is Mr. Pitts with us? Speaker, Mr. Pitts. From Arlington Heights Condo Association. No, okay, yes. Great. Okay, so it sounds like, staff's recommendation would be for a deferral to the July 16th hearing, because advertisement is going out very, very soon for our,
Yeah.
June hearing.
I think it would be a little bit tight to make sure we properly review the plans and advertise all relief, which I think would do a disservice to you if we did not include all the correct relief.
Very-
Mr. Chairman, I move the Board of Zoning Appeals defer matter V-12045-24-3A-3 to the July 16th meeting.
Thank you, Ms. Malice. I will second it. And so a motion made by Ms. Malice for a deferral to the July 16th BZA hearing, seconded by myself. Is there any further discussion? I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes for deferral 4-0. See you in July. Mr. Bowen, can you call the next items, please?
Yes, Mr. Kaplan, and I believe we are back to the appeal that you deferred at the start of the hearing, which is case number V-12042-25-APP-1. This is an appeal by Barry Seymour of the zoning determination letter regarding the vested rights of EHO permit ZEHO 23-00053 on a property located in the R6 zoning district on the premises known as 2127 through 2129 North Troy Street, RPC number 16-004-233 and 16-004-234 within the North Highlands Civic Association. Staff recommends that the board adopt the attached proposed resolution affirming the zoning administrator's determination. Please note there is supplemental material for this case that came in after the application packet was assembled and printed. This is an email from the applicant with 3 attachments. We also have 2 additional speakers who have signed up to speak on this case, DeAndre Willis and Dixie Duncan.
Thank you, Mr. Bowen. Before I call the parties up, I have a quick statement to make. For those avid BZA watchers out there, you'll notice that there is some in the appeals package. You'll notice that there's some correspondence between the Sands Anderson law firm and the zoning administrator in this file. I have verified with our attorney, Martin Krim, who works for Sands Anderson or at Sands Anderson, that he does not represent the appellants before the BZA. And in addition, Mr. Krim has not offered any advice or information to the BZA regarding this matter. And so I just wanted to put that on the record on the advice of counsel. With that being said, we're ready to come forward. I don't know how we'll do this tonight, but are you okay?
Yes.
I get through the area. I believe we have Ms. Baum and Mr. Black
Correct.
will be representing the company tonight. And is the appellant or their representative here? We are. You want to just introduce yourself?
I think it's on.
Evening, members of the board. My name is Steve Brillia from Brillia Hunley. I am legal counsel for Barry Seymour, Gordon, Gulfview Inc. and Advantage Properties. And this is Mr. Barry Seymour. Hello, Barry Seymour. Thank you.
Thank you.
Arlington resident.
Yeah, so we're gonna have the county will go first, then we'll call you up, so you don't have to stand up here unless you want to the whole time.
Well, I was just gonna lay out some things.
That's fine.
So I use the time effectively. I don't keep you all here.
Go ahead.
Is that all right? I'll try to be quiet. I'm just gonna spread some things out. So I'm going to
Get it ready.
Thank you.
Would the council like to? I think you have a microphone too, but like, well, switch on this, Mr. Bowen, but I don't know. I don't know how we're doing it.
I'm hypersensitive about everything being picked up, so. Good evening, my name's Arlova Baum, zoning administrator, joined by Kevin Black. I don't want to mess up your title.
Assistant
County Attorney, thank you. We can go to I have a very, very short presentation. If you want to go to the next slide. Oop, went too far. There we go. This is an appeal of a zoning determination relating to an expanded housing options permit. The numbers listed there, ZEHO 23-00053, which was approved both for the zoning review and for construction prior to a pretty significant court decision in the Norgren case. It was approved in September of 2024, about 2 weeks before the ruling in that case. And the ruling in that case initially issued verbally on September 27th, rendered Arlington County zoning ordinance section 10.4, which formerly had the expanded housing options regulations, void ab initio, meaning they never existed. After that, the appellant sought a zoning determination letter for determination of vested rights based on those provisions found in the Code of Virginia. And in that letter, we took no position on vested rights, but did lay out the steps that were provided for in the November 13th Circuit Court order what the path for pursuing expanded housing options development were for the 45 permit holders that had successfully completed the process before the court ruling. And this order lays out both what the county has to do and what the permit holder has to do. And subsequent to that, actually before the zoning determination letter was issued, the appellant recorded a lis pendens on the subject property per the conditions of this order. And subsequent to that, the county has allowed construction of the EHO development project to pursue in accordance with all other appropriate laws and regulations. Next slide. So to some, our position is, or my position is, I don't have a regulatory authority to issue a vested rights determination on regulations that never existed. And to add, the appellant has successfully pursued construction of the EHO development project and therefore has not demonstrated how he's aggrieved by this letter, and we believe the matter is moot. So our recommendation is that the BZA adopt the proposed resolution affirming the decision of the zoning administrator in this case. I don't know if Kevin has anything to add.
I do not.
Okay.
Thank you.
Sure.
Thank you. I'm going to ask a brief clarification question to expose my ignorance in this process. Would the county normally make a vested rights determination if asked to do so in non-EHO circumstance?
I certainly have the authority with the.
I just don't know that process.
Yeah, I have been asked before and have answered that before. I have written vested rights determinations before.
For both yes and no, right? Both granting and not granting, or that?
I don't get asked very often.
Okay.
The only one I can remember was a positive.
Okay.
Yeah.
Okay, so not often. Okay.
Yeah.
Thank you. Do my colleagues have any other brief clarifying questions? We will have an opportunity to come back. Mr. Borlia, did I get that?
It's brilliant, and I know it throws people, and I know this is a formal hearing, so he was fine. Good evening, everybody. I'm gonna start off by saying, I think we brought you an interesting case.
Yes, that is for sure, yes.
Yeah, and when I took this case and I spoke with Mr. Seymour, and I know I'm on the clock, so I'll be brief. I was aware of the background of this, and I thanked him because it is very intellectually interesting. And although I know this is semi-adversarial with the county because we're appellants and asking the board to reverse Ms. Baum's ruling, her letter, saying she doesn't have authority to issue an opinion on the vested rights, and then there's no aggrieved, he's not an aggrieved party. I do want to go through this a little more carefully and point out some weaknesses in the argument, legal weaknesses, and I'll show or demonstrate, hopefully, to the board that this is established law in Virginia. I understand the political sensitivities of the EHO. We're not here to argue whether it should be adopted or it should be retained. What we're talking about is somebody that applied when the EHO was passed and was the law of Arlington County. There's no question of that. No one disputes that. The EHO was valid when Mr. Seymour, Gordon Gulfview, and Advantage Properties submitted their application. There's a memorandum support in very excruciating detail. We went through the application. This wasn't submitted on the eve of the Nordco case, trying to get it under the wire. It was submitted in December of 23, after the EHO was passed. Mr. Seymour, who is a developer, and has developed in Arlington before, and Alexandria before, successful developments, submitted as the EHO. It was approved. It went through pretty quickly. It's a small development, as you saw on the cover sheet. It was a single family house. And one house came down and two are going back up. As you can see, they're already built. The demolition permit was approved in April of 2024. Now, staff has indicated that
Judge Shell in the Nordgren case issued his initial opinion at the end of September. So again, you can see this project is going on in normal pace. Mr. Seymour, Gordon Gulfview, and Advanced Properties were not parties to the Nordgren case. They were not interpled. They were not required to be part of it and attend and file pleadings one way or the other. Final plat for the subdivision was approved in April of 24. Significant effort to get the subdivision plat. It was approved. That's final plat approval. Building permits were issued on May 7th of 2020. I'll keep going back to the September date as much as you all want to hear. And the final word was much later at the end of October by Judge Shell in the Nordgren case. But building permits issued. Significant reliance. There wasn't any Liz Pendens requirement to get that back then. He's going through the normal process on an ordinance that is deemed valid at that time. Building permit fully approved, June 21st, 24. Construction starts shortly thereafter. There's a demolition request submitted. The demolition permit was issued on September 16th, and the property came down approximately, I think it was, might have been Friday or Thursday, September 20th, 24. It was September 20th, 2024. The building came down, the original single house torn down. The county came out there. All the fencing was up. Stormwater retention was up. No problems. There's never been a problem. It's gone through a normal development process. And then at the end of September, word comes out, Judge Shell has issued this ruling and it said, well, the EHOs. How does that affect the other properties? This is where it gets interesting. The county said, wait a minute, Judge. We've got a number of other applications that are down the pipeline, including Mr. Seymour's development, significant development. What are we supposed to do with this? And they filed pleadings, basically in support of our position now, saying these folks are vested, Judge. You can't just pull the rug underneath their feet. You got to let them keep going. So Judge Shell, and for reasons known only to Judge Shell, granted a partial stay and said, you're right. As to those people who were not parties to this suit, if they file Liz Pendens, then the county can keep process. And I have kind of an odd ruling. Ruling's been appealed, but in reliance of that, Mr. Seymour says, I've got to keep going. I mean, the house is framed, it's coming up. So he kept moving on, files the Liz Pendens, county issues all the permits, does all the inspections as it continues to this day. So then we get to December, and as you would expect, Mr. Seymour goes, well, listen, I'm going to get to a point where I got to sell this property. It's going to have Liz Pendens. I'm going to go to the zoning administrator. I have that right to do. It's a very good question from the chair. The zoning minister has the authority to issue opinions on vested rights in jurisdictions across the state. It's done on a routine basis. And so they do so through council. They submitted the request at the end of December. The beginning of December 2nd. On February 13th, the zoning administrator's opinion comes out and rules that in light of the Nordgren's case, can't really rule on this, and specifically rules opinion that there's no detriment really to this because he's gotten his approvals. He's not a person aggrieved. Well, I want to point out that Liz Pendens is basically the dark shadow over this property. And if you're going to try to sell this property to an innocent purchaser with a Liz Pendens saying, in essence, you got to tear this building down. That's kind of what it means. So asking for the vested rights determination, there is harm. And the fact that he's able to go, Mr. Seymour appreciates the county going to bat for the 45 in Nordgren. He wasn't a party. None of those people were. And it's on appeal. But what's progressed? This is where this case gets interesting. So this is back in opinions issued in February. What's happened since? There's another case. Another one of the 45 goes to the same circuit court that struck the EHO. And that's the Classic Cottages case, which we submitted in the supplemental material. And in classic cottages, another judge, interestingly enough, on May 1st, that's why I said this case is really interesting. It's very seldom do we get different looks from different judges on things. But Judge Huff, sitting as a retired judge in that case, declared in the classic cottage case, one of the 45 EHOs, which is not nearly as far along as Mr. Seymour's development, you're vested. And not only are you vested, but you know that list pendants that Judge Schell said you had to do? Ordered and declared that nothing in this order shall be deemed as requiring plaintiffs, classic cottages, to file any notice in the Arlington County land records, nor is the county required to ensure any such notice has been placed prior to obtaining additional permits and other county approvals required to pursue the projects authorized per EHO permits. Clear and unequivocal. So you've got another ruling from another judge saying, listen, EHO may not be valid. These folks are vested, they can go forward, and the county doesn't have to require list pendants to go further on them. So classic cottage is allowed to proceed with vested rights and not have a list pendants. That's different than Mr. Seymour's property, I would submit. Now I want to talk about a little bit about the law that governs this case. We don't disagree. The county cites 15-2-2311, which is a discussion about deferring defines vested rights. 15.2-2307 also has the vested rights provisions. And what's interesting about 2307 is it was amended effective July 1st, 2024. Again, you can't make this up, that you're getting these little tweaks that, quite frankly, helped Mr. Seymour, helped this board make a decision. That what was added in subsection D of 2307 was a property owner relying in good faith on the issuance of a building permit incurs extensive obligations or substantial expenses in diligent pursuit of a building project that is in conformance with the building permit and the Uniform State Building Code. It's talking about what makes you vested. That wasn't clear before, but what's a substantial effort you've taken, and so the General Assembly added that. It's not in dispute. This property has all its permits, all its inspections have always passed. It's getting pretty close to having a certificate of occupancy. And yet the county says, well, we're not going to say whether it's vested, and because we've given you these things, you're not really to your detriment, not an aggrieved party. I want to point out one major case that I'm not sure it's really cited in the county's brief, but it is in ours, and it's part of the attachments, and that's the Rhodes decision from 2017. This is a Virginia Supreme Court. This is binding. You can argue all this other stuff. You know, that the other case, the classic cottages case, is persuasive argument, but it is another circuit court, same circuit court, another judge in the same circuit court. But Rhodes is the U.S. I mean, it's the Virginia Supreme Court. It is binding on this board. It's binding on the circuit courts, and it talks about how you interpret 15.2-2311C about when something's vested based on previously issued permits. And the Supreme Court specifically rejected the county's argument in that case, saying that the statute only limits subsequent action of a zoning administrator or other administrative officer. The court further held that a limitation of that kind would scant, if any, protection to the property owner and would not serve to remedy the mischief at which the statute is directed. It's kind of an interesting quote. Would remedy the mischief at which the statute is directed. And in Rhodes, they went out of their way to say, this is a very broadly construed statute, broadly construed for the property owners. If they get their permits, if they detrimentally rely, they've acted upon them, and then something changes, even if a court says it's void, and they say that. It is also stated that 2311 was created, quote, to eliminate the hardship property owners have suffered when they rely to their detriment upon erroneous or void zoning decisions. How's that affect this case? Well, you've got Judge Schell saying folks, it's void. He doesn't say voidable, which is a different term. He says void. He says void ab initio. That's void. He didn't say void. And I'm going to keep saying that because it's a huge distinction. The Virginia Supreme Court didn't say voidable. It said void. And the reason they said that is because all across the state, occasionally zoning administrators make mistakes. And if they catch him, and it's within 30, if it's within 60 days, which they added, I think back in 2014 or 15, they catch it within 60 days, they can reverse it. But after that, the property owner, if they detrimentally rely on that opinion, they can keep building. They can keep their fence that's a foot too tall or a foot too far off the line. If they go in there and get their permits, and there's hundreds of cases, happens all the time. Zoning administrators make mistakes. They don't catch it in 60 days. They're deemed vested. And so in 2017, the Supreme Court made it very, very clear that it applies to void zoning decisions. So if it applies to a void zoning decision, then if the ordinance is later declared void, or if it's repealed, what's the difference? If it's declared void later, or if it's repealed for vesting. I mean, you're not going to make people tear down their houses because the zoning ordinance changes, are you? There's no difference. And with the cloud hanging over Mr. Seymour's head is this threat of, well, you got to put that list pendants on and you got to tell people you can buy it, you got a certificate of occupancy, but you may have to tear it down. What else could it mean? It's the only thing it can mean. So respectfully, this board, I think, must reverse zoning administrator's determination. I do want to leave a couple of minutes. I think just about 5 minutes left for Mr. Seymour to say a few words. And he's probably going to repeat some of my things. He feels very strongly that he's followed the rules, that he did what he's supposed to be doing. He wasn't trying to get around the Nordgren case. He was already in the process of EHO. He was excited about doing the EHO project. If you put it up there again, it's a nice project. He's using nice materials. He's trying to fit it into the neighborhood. All the things the EHO's goals at the time were. And the reason why I think it kind of flew through permit approval and the subdivision, things change. He understands that. But to say that you have to continue under this, the threat of tearing down these houses in the future if you're not being vested, I think is conflicts with not only the Rhodes decision, the Virginia Supreme Court case, but then the more recent Classic Cottages case where the court says, yes, these folks are vested. So I will link this to the remainder of my time, Mr. Seymour. Thank you.
Thank you.
If you all have any questions of me, Mr. Seymour.
Oh, let's finish it. Sure. Okay. And then we will have questions.
Okay. Yeah, Barry Seymour, good evening. Thank you for your time and listening to this appeal. The one thing I'd like to read to you is this notice that Judge Shell required to be put in the land records. So the staff report is saying that I'm not an agreed party. Well, this is what I was required that I put in. I went to the hearing on November 13th when Judge Shell modified his order for a partial stay, judgment pending appeal. So to potential purchasers, please be advised that a lawsuit is on appeal, the Court of Appeals of Virginia, and then perhaps the Supreme Court of Virginia, that may void your zoning rights to this property and may result in your right to live in the property being eliminated. So if that's not agreed, I really don't know what is agreed, because basically that's the reason why I need to establish my vested rights. So you're talking to other people here that a lot of times you get use permits or variances or side setback, exceptions, etc. Everything that I did was right by 10.4, everything according to the regulations. I subdivided the property with preliminary plat, the final plat. The zoning people signed off on all this. I had the affirmative governmental act. I proceeded with the progress. I recorded it. You have all the dates that are in your staff report. So I proceeded with the development, and basically right when I demoed the property, then the order came out that Judge Shell had the order saying that Arlington lost the case, and then Arlington basically argued on their basically when they filed the Nordgren appeal of the on November 13th. Arlington County argued on the defendant's objections to the county's
the court's November 13th order for partial stay of judgment pending appeal. This is verbatim from the court. I submitted this as supplemental. The court erred when it failed to consider, hold, or otherwise address the order that by operation of Virginia's remedial vesting statute, Code 15.2, 2307 and 2311, EHO permit holders may have vested rights in the permits issued by the county, depending on the stage of the development of the project. Rights which cannot be revoked, no matter the outcome of the county's appeal in the Court of Appeals or at the Supreme Court of Virginia. They referenced the Rhodes case, which is County of Richmond versus Rhodes. The remedial purpose of the code 2311C is to provide relief and protection to property owners who detrimentally rely in good faith upon erroneous zoning determination and who would otherwise suffer loss because of their reliance upon the zoning administrator's error. By its plain terms, the prerequisites for code 15.2 2311C to apply is one, a written order, requirement, decision, determination made by the zoning administrator. I got the EHO. That was in November 2023, 60 days passed. I got the preliminary plat. When you look at 2307, it states in 2307A that one of these affirmative governmental acts is approval of a preliminary plat or a final plat. I got both of those. The zoning administrator signed off, 60 days went past. So the passage of at least 60 days from the zoning administrator's determination, and 3, material change in the position in good faith reliance on the action of the zoning administrator. Plaintiff's argument are unfounded and confused value should be a straightforward application of the Virginia statute and binding case law. That's Arlington County arguing in the Norton case. But when I ask for vested rights, they're not putting that down. So I'm sitting there saying, what's the contradiction there? Why are they saying one thing in the Northern case on a, when they're trying to argue the case, but then when it comes time to establish the vested rights, because I went through the administrative route as opposed to going directly to the court, because you have to try to exhaust your administrative route before you try to appeal it to the circuit court. So the bottom line is there's court case law, the Rhodes case, there's the EHO case with Classic Cottages that has the same situation, and the circuit court ruled in their favor. And Arlington, I'm sure, is aware of that case, but of course they didn't put that in the staff report. So I would like to appeal to the BZA to approve my vested rights so I can get clear title of my property, basically. Thank you very much for your consideration.
Thank you.
Thank you.
I want to ask a quick question, and then we'll get to the speaker to clarify. I want to, so having read all of the briefing materials and heard both parties, my understanding of the issue that is before this board is that if we were to overrule the zoning administrator, all that simply gets you is a determination on your issue, not a yes or no vested rights. This board's not determining whether you have vested rights or not. Is that your understanding? As a,
I think respectfully, you can say that that was an error and it is vested. That was the determination, yes or no.
My understanding is that the county did not make a determination. And they didn't say yes or no. They just said they don't have the authority to make the determination. So my view here would be, and I'm nowhere near ready to overrule the zoning administrator, just to be clear. But if we were to overrule the zoning administrator, my take on this personally, and I'm one of 4 tonight, is that all we would simply be doing is overruling the zoning administrator's non-making a decision. And so
a remand, I guess, is what you're saying.
Yeah, right. And so then the vested rights discussion, in my view, wouldn't be relevant here. What's relevant in my position is, does the zoning administrator, did she err in not making the determination? Not that she made yes or no.
I think the BZA, given the light of that's right, the specific determination that was made, you could remand it back, and then this topic is open to the zoning administrator. And quite frankly, they
Then-
consider classic cottages.
But yeah, but then that's right, that's beyond.
But no, we're not.
Scope of this board. And so I just wanted to clear that up because we had a lot of case law on, whether it should be vested rights or not. But like I said, my view of one of four, and my colleagues are obviously free to disagree with my assessment, is that that's not really before us tonight.
I think you could make that rule.
Okay, now I am confident that we probably have more questions for probably both parties, but I would like to get for the speakers before we get too in the weeds. So is Mr. Willis with us?
No, but Ms. Willis is, thanks.
Miss Willis, I apologize.
It's okay, no
I'm just
worries.
reading the
I
name.
hear that a lot, as you might imagine. Okay.
You're muted, I cannot hear you. We can't hear you.
I am not muted. Can you hear me
You're
now?
still muted.
I'm not muted. Can you guys unmute me?
Miss
My mute button
Miss
is-
Willis, we cannot hear you. You're
I
muted.
know, I hear you. I am not muted.
Wait, can you hear me?
I can hear Miss Willis fine on my end.
Okay. Oh, great.
Do you want to call in to the number on the website?
I
Do you have a phone that
am
you can
in,
call into?
Give us
We
just
can't
a second.
hear
It
you.
sounds like they're not able to hear any of the
Hang on one second.
online
Might be something
folks
that I
right now.
I don't think convenient things.
I should have asked Nelly some questions.
I'm just gonna try again.
hello, test?
There it is.
All right, great.
I think it was on our end. Thank you.
Okay. Good, thanks. Glad we figured that out.
And can you introduce yourself? Because we
Sure.
definitely missed it.
You bet. I'm DeAndre Willis. I'm a homeowner on Troy Street with my husband at 2112 Troy, which is across the street and a couple houses south of the project that we're speaking about. And I want to speak against the appeal request for the project. I do appreciate the staff report and I support the resolution that is suggested in that report. My main concern is that if the developer of the property is recognized as being vested, that if the county's appeal of Nordgren is not successful, that the county would lose any ability to enforce the requirements that the property be converted to a conforming occupancy in R6. So through the appeal, the developer wants to be able to sell the units without including the notice to buyers. That's been talked about already. I actually disagree with the attorney's theory that the developer was justified moving forward because they had permits in hand when they knew that they would have to file this on the deed. They had ample time to redesign the project to be single family or to a duplex that was easily converted. And frankly, I think they even had time to pull back and not demolish. The fences were up, but my recollection is so was the house when Nordgren was decided. Instead, they went along building it as a duplex as designed and only asked for relief now at this moment before offering for sale. And I want to be clear, I was originally a big supporter of the HO zoning change. I'm not speaking under the cover of that. I live in North Highlands. It's an excellent example of a successful neighborhood with a blend of housing options. And why can't we have that in other parts of Arlington? We've got a wide variety of home types that are desired in the AHO zoning and all at a number of different price points for sale and rent. The home on this property was purchased by the developer at a price of $860,000, which quite ironically is exactly the median price today of a house in Arlington. The two units that are nearing completion in place of that house are being offered for twice that each, $1.8 million each, twice the median price. So projects like this one, in my opinion, clearly show that the county's goals to create missing middle housing are not being met by developer initiatives under the HO zoning. I support finding a way to do it, but that method's not working. And I'm not convinced in the argument that this developer is harmed in a way that could not have been prevented. So those are my comments.
Thank you, Ms. Willis, for your comments. Ms. Duncan.
Hello, I'm Dixie Duncan, and I thank you all for your work. I know it must be tough, and I've been an Arlington County resident for, oh my gosh,
if you have an association with this appeal, can you tell us what that is?
No, I'm just telling you, thank you.
Thank you.
You do not want to be thanked. I mean, I think
Oh,
you
no,
do
no.
a big job. So
I thought you were gonna plow right in, so that's why
Oh, well, I could have done that too, but I'm from the South. We like to do things in the proper manner. I think that the BZA should respect the court's ruling and allow the legal process to play out without,
I'm sorry, are you a neighbor or are you,
Oh,
that's what I meant when I said, what's your connection?
I'm an individual. I live in Arlington County
Okay,
and I've been, living here for 30 years. So
thank you.
I'm just an individual. I live in Glen Carlin
Perfect.
on 200 South Kensington Street.
Thank you.
And I'm very active in my community. Been active in Arlington County. I run a nonprofit. I've been toward school board. I've been very active.
Thank you.
Okay.
Sorry to interrupt.
Sorry, I didn't know that's what you were asking me. Sorry about that. The BZA should respect the court's ruling and allow the legal process to play out without intervention. Developers must respect the rule of the law and wait for the appeals court to rule. I think this is very important because in this day and time, based on what we're seeing in this democracy, if we go against the rule of the law, then this land is not going to be what it should be. And in Arlington County, with the developments, the community should have the highest priority. I agree with what Deandra said as far as we do need things, but if the law is not followed, it should not be approved. It's my understanding that they got a termination letter in November 1st, and there was only 30 days to appeal, but I do not know if that is the exact date. Thank you for your time. Thank you for listening.
Thank you for coming and for your comments. My colleagues would like to ask any questions to either party. Ms. Mounts.
Start with the county attorney and Ms. Vaughn. The staff report that you prepared seemed to argue that the applicant wasn't aggrieved because it sounded like you understood his complaint to be that he could not proceed with construction. Am I reading that right?
Well, go ahead if you want. Sure.
I don't know if
Is it on?
is this okay. I think there were arguments in the staff report that alluded to the letter seeming to indicate that we thought that the appellant needed to wait for the appeal process to be concluded before he could continue. Or that there was that the letter somehow prevented him from being able to actually move forward with the project. And our point is that the project has never stopped moving forward. And so I think the appellant's words today are embellish upon those that were included in the written statements. And there wasn't a lot in the written statements that talked about the harm specifically. And so given that the project is nearly done, it wasn't apparent what the harm was. Yeah, to me.
That's right. I don't know if you want to first address questions to just staff and then to the applicant, because that's my only question, but for Ms. Vaughn.
Yeah, why don't we do that?
Okay. Questions?
Do my colleagues have questions for staff? Mr. Kumana or Ms. Freshman?
I'm interested in your comments, in your feedback on the comment that there's essentially a lien on the property or a threat of harm in such a way that it sounded to me as if they're saying this this puts a cloud over the over the sales. Because I think that, regular people can understand that if you buy a house and there's some kind of a threat or some kind of a construction lien or a tax lien or something like that, that can affect your decision as to whether or not you go forward. And I think the applicant suggesting that, or the appellant suggesting that that's what they're suffering from, and that that's the harm, as if I'm interpreting that correctly, or what I heard. And then if that's the case, do you agree that that is essentially a negative for him going forward, completing the project and selling?
So if I may, to address your question on, essentially it's an aggrievement issue question, as I understand it. For this body to take the appeal and to hear the appeal, the aggrievement is part of that process, but that is an aggrieved status that was put in place by that would be by the county. That's not what we have here. The decision was made by the court. And so just as Classic Cottages did, they went to the court to get their remedy. Okay. As Mr. Regalia was saying earlier, if the partial stay, what we have here, what we're clear about is that we have a determination or ruling by the circuit court that says these regulations are void ab initio, they didn't exist, right? So in order for, as Mr. Regalia was arguing that the county was saying, hey, there's and I didn't make the argument, I can't represent to this body whether at this time whether the county actually used arguments that said, hey, these 45 properties are vested, and certainly cannot say by looking at the order that the court determined that they were vested. If the court, I would just simply ask, if the court determined that there was vested rights, why are we here? All right. Okay. If the court determined that there was vested rights, why would Classic Cottages go back to court to seek a remedy? The problem that we have, and the reason why the zoning administrator did not issue a determination on vested rights here, is because it's not the zoning administrator's call to opine essentially on a ruling that was made at the circuit court level. The reason why we're saying that there is no, that this is moot is because the county has followed the circuit court letter, or excuse me, order to the letter, and this project has proceeded. If there is going to be a harm, it is not, this is not the appropriate forum for it, because the aggrievement wasn't established by the zoning administrator or anything that the county has done. So that's why we say, as far as this proceeding is concerned, the agreement status doesn't exist, because they have gone through the process and have been able to continue development. We're following the order. But clearly, obviously, we know that the judge has ruled that the regulations are void ab initio, and the judge stayed the order. The judge didn't, which is a pause. Okay, so that's where we are, and that's why the zoning administrator could not at that point issue a determination on vested rights over a ruling that was taking place in circuit court.
Thank you.
You're
I'm gonna follow up on Ms. Freshman's comment, and I suspect I know what you're gonna say. If there was no Northroom case and the zoning administrator, although we're taking a leap here, because it would never happen. But if the same non-determination came out, would that change your opinion on being aggrieved? I know it's.
Well, then I don't want to get into hypothetical necessarily, but I do want to understand your question. Could you please repeat? I'm sorry.
I'm trying to get at, I guess what I'm trying to get at is, can't this appellant be aggrieved by both the circuit court and the county, whose position is, I can't make a determination? Right, I mean,
I see what you're,
And I guess to be clear, I'm not sure that, this board typically would, even if we don't believe that the appellant is aggrieved, we would still make a determination on the merits, because it can go to the circuit court and we don't want it coming back to us. So at the end of the day, I'm not sure that that's going to affect our decision tonight, but one of the proposed findings is about aggrieved, and so that's why I'm asking.
Sure. In order to be aggrieved, she would have had to have made a determination. So if she made a determination, hey, your rights are vested, or your rights are not vested. If she didn't make a determination, there's no determination that is applying to them to set in place the aggrieved status, if you will.
I get, okay. Thank you.
Yeah,
We don't need to argue.
Sure. No,
No, thank you.
That's what we're here.
That's in line. Ms. Smith,
Yeah, another question.
Ms. Malice.
Yeah, so, Chair referred to the resolution. One of the whereases in the resolution has to do with completion of the project. I mean, would you, in light of the applicant's current arguments, change any of these? Any parts of this resolution?
The language says the appellant has continued to successfully pursue completion,
Okay,
not that it's done.
at this point it is done.
I don't think
Doesn't
we've
have to
issued,
CO.
yeah, there's no certificate of
It was on the
occupancy.
market. That doesn't have to have CO. Yeah.
Before someone moves in there,
Okay.
yeah. The last step is,
So it's not, your mind, it's not,
no.
not completed. Okay, thank you.
Thank you. Mr. Kumana, I don't want to leave you out. I just want to confirm if you have any questions.
None for me
For
right
staff.
now.
You're muted, or we can't hear you.
No questions if you can or can't hear me. No questions.
Thank you, Ken. Questions for the appellant? Ms. Malice.
The second court order allowing 45 of these projects to go forward. To me, it was pretty clear that the judge was saying you are not vested. None of these projects are vested.
If I might, I think it was Judge Shell's attempt, knowing that there was going to be an appeal because the county said they were. If you read what he's trying to do is, I think the term I would use is split the baby. Those people were not parties to the suit. He did not have particular facts about whether some satisfied all the prongs that you have under the state code of being vested or not. And you could have somebody that had applied and gotten EHO zoning, but hadn't done anything. They wouldn't be vested probably. I mean, that's the analysis that's done.
To me, it seems pretty clear that it was a conditional going forward, and therefore.
It's heavy as best, I guess. In case he was wrong, these people wouldn't be sitting for a year and a half.
But nevertheless, I thought it was pretty clear that, if the ruling went against the developers, they were taking a risk by going forward. And the risk was clearly on part of the developer, whether they wish to go forward or not.
Well, I think I'm going to guess, I'm not guessing what judge, I don't think anybody can guess really, but I would presume that what the judge wanted to make sure is that if somebody was going to make an argument that they were vested, they'd have to do it in a different form. Because it wasn't before him, and you'll have to come back, but you need to tell these folks that you may or may not be vested.
Well, the judge was saying you may not even get to keep your project.
Yeah, I don't think he said that. The specific
I read all
resolution.
the transcripts. I'm sorry.
I
read all the transcripts and Judge Shell basically said, this is a procedural case. We're not entertaining arguments on the vested rights. So he said, that's it for another courtroom. He said, so he did not rule on that. He just gave that judgment pending appeal. He put that, we had to put the land in the land records, but he did not hear arguments and take any position on that. That's why he put that in their land record.
That's for another courtroom. This is not a courtroom.
Well, this is the administrative route, which is the preferred route. You're supposed to exhaust your administrative efforts before you go to the court, and that's what I did.
Well, and I'm looking at the order now, the December 13th order, so I
don't think we, from my standpoint, you don't have to get into the detail, but it's clearly that's what staff is relying on. That's what the county is relying on, is that there's some question as to, what happens to these projects should the ruling go against the county.
Well, I know I quoted Judge Huff in the classic cottages, another circuit court, equal standing, equal authority, has done a different ruling and said, I don't need to wait for anything. You're vested. That's the rule of law in that case issued May 1st. Now, I understand staff didn't have that when they were doing the administrative review and the determination that was issued in February 13th. I don't know if that changed their analysis or not, but just to say, we'll take it to court and let them decide is plain. The applicant has the right to come before this board and say, listen, we're entitled to a determination. No, but the county is, though. The county is saying this isn't the right forum for that. That's what they're saying. And what's also interesting is the argument that they've gotten all their permits so they're not adversely affected. That's not what the zoning administrator said. It's not in the zoning administrator's determination.
I believe that the county's position was that they did not have standing or were not aggrieved. I don't.
Was not inappropriate to come.
Right. They didn't say it was not inappropriate to come here. It's always appropriate to appeal a zoning administrator's decision to come before us. And I did not hear that from the zoning.
Oh, the appeal is, of course, but I think if you remand, they're going to say she doesn't have the authority to issue. That's their thing. She does not have the authority to say whether they're vested or not.
Well, that's what's before us.
That's right.
Right.
That's what I'm trying to get back to be honest with you. Right. Because the issue that they've gotten their permits, so they're not aggrieved. That's not it. That's not one of the bases of the determination of February 13th. I mean, I think I don't know what they're thinking. I'm just saying because they've done what everybody has told them to do, they're getting punished for it. And I disagree with the citizen that they were doing things out of any nefarious intent. I mean, they applied for the EHO before Norton was even on the radar.
Is there anything further from any of my colleagues? I will close the public discussion of the public portion of this hearing and with discussion with the board.
Thank you very much.
Thank you. Would anyone like to make a comment or a motion? Ms. Mount.
I appreciate that, the applicant is procedurally correct in terms of making an administrative effort to move this along. But given what I understand about what the judge ruled, I can understand why staff would be reluctant or unable to make a determination. But as the chair pointed out, the best thing, and even if we found in favor of the zoning administrator, it would only remand the issue back to her. It would not solve the investment issue.
Thank you, Ms. Mellis. Anyone further? I concur with my colleague, Ms. Mellis. I do feel that the appellant is aggrieved and move forward to the merits of this before me, because if the zoning administrator just doesn't make a decision, well, that's by itself not being able to get finality to me is an aggrievement. And I do appreciate the county's position where it was really the circuit court who aggrieved the appellant here. But I think that there's enough agreement to go around. So I think both parties can provide the necessary agreement. But the question before us tonight is whether the zoning administrator erred in not making a determination on the vested rights of this project. This board must presume that the zoning administrator is correct, and the appellant has the burden of a preponderance of the evidence to overcome that burden. And my dilemma or my concern here is that a circuit court has issued a lit pendens in this case, and this appellant is essentially trying to come to the BZA for us to, what in effect would be to overrule that circuit court order. And I don't believe that this court has that authority to do that. What did I say?
Court.
Oh, yeah, we are definitely not a court. Sorry. Thank you. This board does not have the authority to do that. And as in the classic cottages case, they went to a circuit court who was able to get an order, maybe not overturning Nordrum, but at least disagreeing with it, or, I don't know the procedural posture of that case, right? But we are decidedly not a circuit court and don't have that authority to, what in effect would be to moot a lis pendens by a circuit court judge. And so that's kind of my thoughts on this case. That being said, this freshman.
I would just concur with your remarks, Mr. Chairman, but also just to say that I appreciate that the appellant seems to think that they need to exhaust all administrative options and may have interpreted that that's why they're taking this case. But I think in the end, as with that other case cited, that we can't overthink it or certainly not overrule something that the courts have done. And I think probably that's their next step.
Thank you, Ms. Freshman. I'm just looking at our resolution. So if we will give me a second to. Right, I don't know how my colleagues feel if we need to make a agreement determination in our resolution, or we could just take it out. And I would like to change the third whereas. 1, 2, 3, third, no, in addition to the agreement, to striking the fourth whereas, but the third whereas, we probably don't need to go into a discussion about how much of the project has been successfully completed.
Not like that, project.
Yes,
You take out,
they got and the applicant continue to successfully pursue completion of the development project.
take out both words.
And take out the whole fourth whereas. So that would, I guess if I were to make a motion, that's what I would make.
She's marked to resolve.
Then I will. Ms. Malice, would you like to make a motion? Mr. Hey. I'll ask for comment.
I move that the BZA adopt the proposed resolution below, affirming the zoning administrator's determination, and that is in case number V-12122-25-APP1. And I propose we modify the resolution by taking out the last clause of the third whereas, so that that clause ends in has allowed all further development of the appellant's project, period, and removing in its entirety the fourth clause.
Thank you, Ms. Malice. Ms. Freshman?
Second.
In a motion to uphold the zoning administrator made by with the proposed resolution with the changes stated, motion made by Ms. Malice and seconded by Ms. Freshman. Is there any further discussion? I will just add that I incorporate my comments previous to the motion into this comment section, and I'll just add that this upholding the zoning administrator will also give the appellant what they want in having exhausted their administrative remedy and can go to circuit court. Hearing no other further discussion, we'll call the roll. Ms. Malice?
Aye.
Ms. Freshman? Mr. Kumana?
Aye.
Chair votes aye. Motion to uphold passes 4-0. I believe we have some minutes to approve.
It's not on the.
Oh, that's all.
Just look.
April 23, 2025
Where?
on the website.
Oh,
I will move approval of the April 23, 2025 BZA minutes,
second,
seconded by Ms. Freshman. Is
second,
there any further discussion? And we'll call the roll. Ms. Malice. Ms. Freshman. Mr. Kamana.
Aye.
Chair votes aye. Motion for approval of minutes passes 4-0. Is there any further business?
Mr. Kaplan, I do believe there's another small administrative matter to attend to.
I'm gonna miss.
The appeal that you scheduled earlier this evening for the July hearing, ZApp 25-0007. Do you intend to hear that on the issue of timeliness, on the issue of merits, or on both?
A good question. Thanks, yes. Timeliness, yeah, sorry, thanks for jogging my memory on that. I think we just want to hear timeliness.
Thank you very much for the clarification.
We need we do a motion, or is that? Should we do a quick motion on that?
Mr. Chair, I ask unanimous consent. I have unanimous consent to modify the scheduling of the aforementioned appeal to clarify that it is only for the purpose of establishing timeliness.
Thank you, Ms. Malice. Hearing no objection, motion is so approved. Thank you for bringing that up.
Absolutely. Thank you for attending to a clarification.
All items having been on the agenda being complete, this meeting is now adjourned.
Have a nice night, everyone. Thank you.
You too, sir. Thank you.
Feel better?
Thank you.
Yeah, sorry about that. All of them, huh?
Yeah, the whole house. I just figured it was better for everyone if I was here. No need to risk it. I'll talk to you all soon.